Last month, Judge Mark Pittman of the U.S. District Court for the Northern District of Texas issued a ruling that could fundamentally alter federal power in the United States. The Constitution limits the federal government to 17 distinct powers. Since then, the courts have used 3 of those powers to expand the scope of the federal government: the Interstate Commerce Clause, the Tax Clause, and the Necessary and Proper Clause. Today we are going to go through the court cases that expanded those powers and how this one case might change all of that.
My name is Mac Latimer, and this is Imagine Better.
Before we dive into the history, please hit the like, subscribe, and notification buttons, and stay tuned to the end for an exciting new feature. It's a huge help. Our first stop is the Tax Clause. The Constitution says Congress has the power to lay and collect taxes, duties, imposts, and excises, to pay the debts, and provide for the common defense and general welfare of the United States. The Supreme Court has fought over 2 big questions regarding this clause. The first question is, what exactly are the limits of taxation? As outlined in the Constitution, there are 3 explicit limitations to the tax power. Congress cannot tax exports, cannot levy unapportioned direct taxes, and cannot levy indirect taxes that are not uniform. But the real question here is, what exactly is a tax? Is a tax anything that's called a tax? Are fines and fees that the law does not call taxes still taxes? Is any charge from the federal government a tax? And could something that doesn't raise revenue at all but prohibits a conduct be a tax? These are the questions that the Supreme Court has dealt with over the past 200 years. There are 7 significant cases here, so we'll go through them rapid fire. In 1866, in the license tax cases, the Supreme Court ruled that the license fee is a tax, but the license itself is a regulation. So it was unconstitutional if the license permitted or prohibited intrastate commerce, but the fee itself was a tax and therefore constitutional. In 1922, in Bailey v. Drexel Furniture Company, the Supreme Court decided that a tax adapted solely to the achievement of some other purpose plainly within state power is a penalty and not a tax, and is therefore unconstitutional. In 1950, in United States v. Sanchez, the Supreme Court ruled that a tax can have a collateral regulatory purpose and effect as long as it doesn't aim to eliminate the regulated action. In 1953, in United States v. Carrigger, the Supreme Court ruled that the essential feature of a tax is to raise revenue. In 1978, in United States v. Sotelo, the Supreme Court clarified that although a penalty is not a tax, something called a penalty can still be a tax. And finally, in 2010, in NFIB v. Sebelius, the Supreme Court ruled that as long as the individual has a lawful choice on whether to engage in the taxable action, it's considered a tax. In summary, a tax is a mechanism to raise revenue for the government. It doesn't have to be called a tax and can alter behavior in purpose and effect. However, it cannot aim to permit or prohibit behavior outside the other congressional powers. The second question is whether the tax clause gives Congress an independent spending power for the general welfare. As James Madison describes it in Federalist 41, the common defense and the general welfare is a general term followed by the specification of the objects. In other words, the phrase is a reference to the following powers in Article 1, Section 8, and not a power unto itself. Madison points out that if Congress can spend money on anything it deems to be in the general welfare, there is no limit to its power. And that's how the Supreme Court interpreted this clause until 1936. That all changed with FDR and the New Deal. After FDR's landslide victory, he pushed the Supreme Court to expand Congress's powers past anything the founders ever envisioned. For the taxing power, that came through 2 cases, United States v. Butler and Helvering v. Davis. The first case, Butler, was a challenge to the Agricultural Adjustment Act of 1933. This act taxed food processors of certain agricultural products deemed in surplus. Then they turned around and paid farmers not to produce those surplus products. Whether this was good policy was not the question, although the answer to that is undoubtedly no. The question was whether the Constitution provided a new power to spend on the general welfare. Despite striking the act down under the 10th Amendment, the Supreme Court adopted an expansive reading of the tax power, saying, "It results that the power of Congress to authorize expenditure of public monies for public purposes is not limited by the direct grants of legislative power found in the Constitution." Then, just a year later, the Supreme Court used that ruling to expand Congress's power yet again. A shareholder of the Edison Illuminating Company sued that company over Social Security taxes, claiming that the Social Security Act was unconstitutional. Despite not having justification in any of the enumerated powers of Congress, the Supreme Court held that Congress may spend money in the aid of the general welfare. Our second stop brings us to the Interstate Commerce Clause. The Constitution gives Congress the right to regulate commerce among the several states. Before the states ratified the Constitution, the discussion around this clause was not over the extent of its power, but over whether the power should be in the hands of the states or the federal government. In Federalist 41, James Madison says that if the states have the power to regulate the trade between state and state, it would nourish unceasing animosities between them. Like the taxing power, the founders included the Interstate Commerce Clause to right a wrong created by the Articles of Confederation. During that time, states imposed tariffs, quotas, and other regulations on trade between the states. Those laws destroyed trade between the states and pushed trade towards foreign countries instead. The founders wanted to eliminate those laws, so they took that power and gave it to the federal government instead. That switch mostly kept states and the federal government out of regulating interstate commerce, except to open up trade between the states. That's when the Supreme Court decided to end the practice of restricting the Commerce Clause. In 1942, in Wickard v. Filburn, the Supreme Court held that wheat not intended in any part for commerce, but wholly for consumption on the farm, are within the commerce power of Congress. In other words, even if a product is exclusively consumed in the home where it is produced, it is still subject to interstate commerce. The reasoning goes that because home consumption decreased the overall demand for wheat on national markets, it should be included in interstate commerce. In short, every human action, even tangentially related to commerce, now fell under the Interstate Commerce Clause. The Supreme Court has only once partially pulled back from that ruling in United States v. Lopez, when they ruled that merely possessing a firearm is not included as commerce. Finally, the third stop is the Necessary and Proper Clause. The Constitution states that Congress has the power to make all laws which shall be necessary and proper for carrying into execution the foregoing powers, and all other powers vested by this Constitution in the government of the United States, or in any department or officer thereof. In Federalist 33, Alexander Hamilton, a known advocate for large, expansive government, declares that the constitutional operation of the intended government would be precisely the same if this clause was entirely obliterated. He goes on to say the power is to address the pragmatism of legislation. For instance, since the Constitution gives Congress the power to mint coins, the Necessary and Proper Clause gives them the power to build a building to mint those coins in. Essentially, the clause tells the Supreme Court to use common sense regarding the other 16 powers of Congress. In 1902, in Felton v. United States, the Supreme Court said that under the Necessary and Proper Clause, Congress may prescribe any rule or regulation which is not itself unreasonable. This ruling drastically expands the powers of Congress to what the Constitution doesn't prohibit, rather than what the Constitution permits. Between these three powers, the only real limits to the federal government upheld over the past 80 years have been the first 8 amendments to the Constitution. So that brings us to today's case. In 1868, Congress passed a law that said, "No distilled spirits plants for the production of distilled spirits shall be located in any dwelling house, in any shed, yard, or enclosure connected with any dwelling house, or on board any vessel or boat, or on premises where beer or wine is made or produced, or liquors of any description are retailed, or on premises where any other business is carried on." Hobby Distillers Association sued the federal government in December of 2023, claiming that that law was unconstitutional. They argued the law did not fall under any of the enumerated powers of Congress, including the three we talked about earlier. The United States District Court for the Northern District of Texas allowed the lawsuit to go forward and issued a ruling on July 10th of this year. Before diving into the ruling, let's examine the relationship of district courts and the Supreme Court. The federal court system consists of three levels: one Supreme Court, 13 circuit courts, and 94 district courts. Theoretically, all of the district courts and circuit courts are supposed to rule based on the Supreme Court's interpretation of the Constitution and not their own. In practice, judges clearly have their own interpretations, but try to loosely keep them within the bounds of current Supreme Court jurisprudence. So when the district court examines this case, the ruling is almost more important than the reasoning. The court's opinion evaluated the law under the tax power and the interstate commerce power, supplemented by the necessary and proper clause. With the tax power, the court held that the law did not raise any revenue and therefore was not a tax. With the necessary and proper clause through the tax power, the court held that even though Congress can regulate alcohol from when it's created until it is sold, it cannot regulate alcohol before that. With the Commerce Clause, the court gets creative. It holds that the Commerce Clause does not apply because federal regulations don't comprehensively regulate alcohol. The example that the court gives is marijuana because the federal government regulates it so comprehensively that it regulates it to the point of prohibition. Finally, the court ruled the law unconstitutional and gave the circuit court 14 days to overturn that ruling before the injunction went into effect. The Fifth Circuit did not take them up on that offer. That means that the federal government will be prohibited from enforcing that statute across the country. Keep an eye out for other district courts to take up this issue and possibly push the issue up to the Supreme Court. Either way, that's a win for the Constitution and the United States. So what are you waiting for? Go out and start your own home distillery today. If you want to support our channel, we have a brand new way for you to do that. Join our new Discord server and engage with our community. Let us know your thoughts about our videos and what you want us to cover next. Follow the link in the description to join. With your input, we can take Imagine Better Media to the next level. And while you're here, click here to check out our other stories.